Regular meeting of the Morris Plains Planning Board for August 19th, 2024. Would you please stand for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I hereby announce that this meeting is being held in accordance with Chapter 231 of the Open Public Meeting Act. Proper notice of meeting dates has been given to the Morris News-Bee and the Morris County Daily Record and posted on the bulletin board in Borough Hall. This meeting is a judicial proceeding. Any questions or comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision, and decorum appropriate to a judicial hearing must be maintained at all times. Roll call, please.
Mr. Augenblick,
Present.
Mr. Garafaglia,
Present.
Mrs. Kelly,
Present.
Mrs. Stecker, here, Mrs. McCluskey,
Here.
Mr. Kelly,
Here.
Mr. Bezel, Mayor Carr,
Present.
and Mr. Drutzler.
Present.
Okay, are there any comments from the public to speak on matters that are not on the agenda for tonight? Yes. State your name and address.
My name is Lee Connor, I'm 2 Tower Hill Road, and I do have a question in the spirit of the education that the public has been getting at these meetings. I'm not talking about the McDonald's application or property, I'm talking about vacant properties in town that occasionally come up and tend to stay vacant for a while. Surprising to a lay person, they look like great opportunities. So I have a twofold question. One, in your experience as elected officials and planning board members, what are the main reasons concisely that causes these things to linger on in a vacant state? And 2, what can any board or well-meaning group of citizens do to help?
Didn't get that. Could you try it again?
Help attract businesses that will enhance our town?
I'm gonna let the mayor answer.
Yeah, so I think, Lee, we discussed this a little bit the other day, and, I'll speak for myself. I'm constantly looking for people to go into vacant spots. It's all about networking and that sort of thing with different people, so that's ongoing, and I'm sure there are a lot of other people that do that as well. You can put an owner and a potential tenant together, but if they can't come to some sort of terms or agreement, that's between them. The town doesn't intervene anyway with those kind of negotiations. There are, I'm not exactly sure in any of these zones exactly how many different uses that are proposed or are accepted in all these different zones. So there is a variety of different businesses and different things that can go into various zones within the borough. So it really depends on a person who has an idea, thinks it's gonna be profitable, whatever business he wants to put in, and then for the property owner as well to accept that business and accept the terms of you know, a potential renter or lessee.
So when a property has been vacant for, 4, 5, 6 years, it's just those conditions did not obtain, there was nobody that could make a deal with the owner, or
I mean,
vice
you'd have to
versa?
speak to the owner on those kind of particulars, but I know in this case here, just on this Friendly's lot, there was little to no action. There was one proposal that I think would have been probably detrimental to the borough. 50 units of apartment buildings on that one parcel over there, so with not adequate parking or anything else like that. That would have been detrimental for the schools, our services, parking, neighborhoods, all that sort of thing, so.
I guess
And
it's
that's
just-
really one of the only things that I heard in the past few years that came across the table for that one, just that one particular municipality.
Thank you, I appreciate that, I guess it's just hard for a layperson to understand, but seems like such a great opportunity, but I thank you.
Could I add something?
Oh, absolutely.
The master planning committee here spent almost 2 years with our town engineer and our town planner. We went through all of the zoning, all of the specifics. We try to be open and look at it from a developer's or property owner's point of view, as well as citizens. But like I said, we spent 2 years, so we were trying to say we were very receptive to people, and what would be conducive and helpful for the citizens and stuff. So we did work behind the scenes, so it is up to date. What we see that's out there, it's available and would be beneficial to the town as well as to a property owner.
Thank you.
Are there any other questions on matters that are not on the agenda? Okay, we'll go to correspondence and bills. Karen, do you have any correspondence?
No, I do not.
And Mr. Kelly?
Yes, I have purchase order number 202-41331 from Phillips, Price and Greigel. It's planning in general for $1,600. I have, purchase order number 202-41332, to Marizzi Falcone LLP, legal services for $227.50. And purchase order number 202-41333 from Marizzi Falcone LLP, legal services for $227.50. If there's no questions, I make a motion to approve.
I second that.
Roll call, please.
Okay, Mr. Odenblick,
Yes.
Mr. Garavaglia,
Yes.
Mrs. Kelly,
Yes.
Ms. Stecker,
Yes.
Mrs. McCluskey.
Yes.
Mr. Kelly,
Yes.
Mayor Carr,
Yes.
and Frank Russo.
Yes.
Okay, the next, matter that we have on the agenda is the application PB 1-20.
Excuse
I'm
me.
sorry, minutes, I'm sorry, yes. The minutes of the July meeting, July 15th meeting.
Okay, I would just like to state one correction. It's on page 331, it's the first page. It would be Mr. McAvidi was advised to go before the council regarding an ordinance, taking out Mrs. Stecker's advice.
Okay. Are there any other corrections or additions? Could we have a motion to approve the minutes of the July 15th meeting?
So moved.
Second? Second. All in favor?
Aye.
Opposed? Abstain? No. The motion, the minutes are approved. We have the application PB 1-24 McDonald's USA LLC. It's, on the agenda for completeness only. And, Mr. Brewer, our attorney, is going to explain what completeness means. And Mr. Vitolo, do you wanna come on up?
You can listen to him, Mr. Toll.
Welcome.
This is really, the first, or really the second step in an application. You may all know, and you may be here from McDonald's. Really, the first step is that the governing body, drafts a zoning ordinance, says what you can and you can't do on various pieces of property, under what conditions, how big it has to be, how far back it can be, how tall buildings can be, and what type of uses. Then if an applicant wants to do something with it, they have to submit a very formal set of information, an application plus a lot of formal pieces of information. And there is a checklist, a list of all the things that have to be submitted before the board can even think about, think about whether or not it should be approved. And that's the stage we're in now. There's not gonna be any testimony tonight, it's just, that's why it says completeness only. It is, they've submitted information and there's a few things that they're asking waivers for. That's not appropriate, and we do it later. There'll be a little bit of that discussion tonight, but there'll be nothing on the consideration of whether or not it can be approved. It's simply the question tonight, did they supply all of the information that they are legally obligated to provide? And should a few of those things be put off or waived? That's what's gonna be answered. Once the determination is made that they are complete, if it's tonight or next month, whatever it is, after that, then they will send notice out and you'll be notified when it will be heard, when the actual hearing will be heard. But tonight, it is simply it's only, and there's not gonna be testimony from the applicant at all, it's just going back and forth with the professionals on what was submitted.
Okay, so, we'll start, I think, with your report, Mr. Ryden, your reports.
Yes, thank you, Madam Chair. I have an August 2nd, 2024 report that I submitted to the board regarding the completeness of this application. First, we start with checklist E, which is the site plan checklist. The applicant is requesting waivers from 10 items under that checklist. I'll start with the, and go through each one and describe what they are to you. The first one is item 34A, B, and E. This is information regarding water courses, bridges, and rock outcroppings on the property. There are none of those features on this property, so I believe it's not applicable. The next one is item 35C. This is for storm drains, culverts within 200 feet of the particular property in question. This development has no stormwater impacts because it's a previously developed site, so this is not applicable as well. Next item is 38A through C, which relates to wetlands information. Again, this property has no wetlands, so I believe this is not applicable. Next is item 47D and E. This relates to water wells or septic systems on the property. There are none on this property, so I believe that's not applicable as well. Item 50 is for information on industrial operations and storage of chemicals. This application does not involve any of that. So again, this is not applicable. Item 54, details of existing signs have not been provided. The applicant is requesting this waiver because all existing signs are being removed. They will not be relevant at all to what we're going to deliberate here. So that, again, I think is justified for the waiver. The next one is lighting data and existing lighting not provided. Again, all existing lights are going to be removed from this property and are not relevant to the new development plan. So I, again, believe that waiver request is valid. Next item is 57. This has to do with final contours within 100 feet of the property. This development doesn't impact anything outside of its boundaries. I don't believe that's relevant here either. Next one is item 58, which relates to the environmental impact statement. The applicant's requested a waiver. Here they have, their rationale is that the site is already developed. There's really no environmental impacts. And I do note that they did submit a phase 1 environmental assessment for the property, which has to do with the past uses and what might be there. So I believe that's sufficiently covered. And the last item under checklist E is steep slopes. Again, there's no steep slopes on this property, so I believe that is valid for a waiver. Now we move to checklist F, which is the variance checklist. The first item there is 24G, 1 through 4. This relates to an analysis of surrounding properties within 500 feet of the PQ, the property in question. This information we typically deal with when there's a residential variance application, like for a setback or a height or something like that. We need to know what all those other buildings in the area are like to make some comparison. This is not related here, so I think that's a valid waiver request. Item 25 is flood hazard areas. Again, this is not in a flood hazard area, so it's not applicable. Item 26A through C. Wetlands, again, no wetlands here, not applicable. Item 29, steep slopes. And there's some overlap here as you're hearing from the other checklist. Steep slopes here, again, not applicable. And item 30 is the last one for riparian zones. Likewise, there are no riparian zones involved with this property. So that's the list of waivers they're requesting, and I'll be happy to answer any questions or that you might have.
I have a question. Should the applicant be giving us elevations of the proposed building? Have they submitted any elevations?
They have.
They have?
They have.
I haven't seen them. And what about hours of operation? Have they submitted that?
That's not a checklist item. That will be part of the presentation when the site plan application is actually heard.
Okay, thank you.
Bill, just item number 58, Have you reviewed that report, or your?
I've gone through it, yes, it covers the, you know, it's more, it's a phase one assessment is when the property's being transferred to see that there's no environmental hazards on the site. And I don't see any issues.
No issues.
But again, these are waivers only for completeness, and they're not dispositive of these items necessarily. So that can be discussed in more detail as we move into the application.
So based on your testimony here tonight and the report, you believe that the waivers are appropriate
I do,
and that they have provided everything and we could grant completeness?
so yeah, once these waiver requests are acted on, and if they're approved, then the application will be complete. All the other checklist information has been provided.
Okay, and now I'll ask Liz, we have your report. Do you have any issues as to completeness?
I do not, Madam Chair. I concur with Mr. Ryan.
Okay, excellent. So, do you have any comments you wanna make, Mr. Vitolo?
There's a time to say things and a time not to, and I'm not gonna say anything. So, thank you, Madam Chair.
Okay, so, any discussion by the board as far as completeness is concerned?
No, I mean, I think they made all the requirements here. We got enough information, it seems. So I'll be happy to move the waivers for the 10 waivers for checklist E and the 5 waivers for checklist 5, and deem the application complete.
Do we have a second?
Second.
Is that Mayor Carr who
Yes.
seconded it?
Yes.
And could we have a roll call vote, please, Karen?
Yes. Mr. Openblick,
Yes.
Mr. Garavaglia,
Yes.
Mrs. Kelly,
Yes.
Ms. Stecker,
Yes.
Mrs. McCluskey,
Yes.
Mr. Kelly,
Yes.
Mayor Carr,
Yes.
and Mr. Drusen.
Yes.
Excellent. So we will see you back here next month. You will do your notices, and we're looking forward to that. Before you go, though, I just want to ask anybody in the audience, we're not going to have any testimony tonight. You can't ask about any of the questions as far as this application, but do you have any questions about how the process is going to go forward? Come on up and state your name and address and ask your question.
Sure. Carl Ring, 22 Dayton Road. I just had a quick question on the waiver for the environmental impact assessment. Like, is that something that, like, I'm assuming increased traffic, possible air quality impact, like, so is that an appropriate waiver to allow for if there could be environmental impact?
Well,
Or are we just talking about like groundwater, things like that?
correct, and there will be testimony later on during the application process about odors, lighting, any spillover of those things, so that will be taken care of when we have the testimony.
Okay, so it's still appropriate to allow the waiver even
Yes.
though some of that?
And these waivers are only for completeness, only to deem the application complete,
Okay, thank you.
okay?
Excuse me, sir, I didn't get your name or your address.
Carl Ring, 22 Dayton Road.
22 Dayton?
Yep.
Does anybody else have any other questions? Yes, come forward, please.
I'll yell from here. Mark Eschbacher, 120 Littleton Road. So in the process.
No, you didn't get your name and address.
You have to be on the microphone so it's
Yeah.
on the record. Just right there, so
Yeah.
get a picture.
Mark Eschbacher, 120 Littleton Road. So
Get that, Karen?
Yes, I
just in general, so next month, there'll be testimony and discussion, consideration. Does the final decision rest here, or does it then go to the Board of Adjustment?
No, it rests here, okay? And so the way it will go is the applicant will bring in each of his experts. It'll start with their engineer, I guess, and their planner and their traffic expert. And each one of their experts will provide testimony, okay? Our professionals will then have an opportunity to ask questions. The board will have an opportunity to ask questions of that witness. Only things that that witness testified to, okay? And then the members of the public will be able to ask that witness questions about their testimony. When they've gone through all of their experts, at the very end, everyone will have an opportunity to ask questions about the whole development, about anything that's going on here, and they will have an opportunity to make a comment, okay? So if you want to make a comment, you can't send a letter, you have to come here and do it in person.
Right.
Okay, and that gives the applicant the opportunity to sort of cross-examine you,
Sure.
you know. So that's how it's going to take a while. It probably won't be over next month. So, you know.
That's helpful, that gives a good perspective,
Right,
thanks.
and the people that will be notified will be the people that live within 200 feet. But it will be on the bulletin board here, it'll be in the, you know, as the notice said, it'll be in the Newsbee and it'll be in the Daily Record. But only the ones that live within 200 feet of the property will actually get a certified letter,
Okay.
okay?
If there is a large interest in the next meeting, more than capacity here, will the meeting still be held then here, even if it's potentially standing room only?
We'll have to see what the fire department allows and we'll play it by ear,
Okay,
okay?
good, thanks.
Yeah, you're welcome.
Can I ask a question?
Sure.
For perhaps the benefit of the homeowners, it's my understanding that this is an approved use. So they're not asking for a variance for the use of it. What I'm asking the town attorney is, we can deny the variances they're asking for, depending on the information that's presented and depending on how the board votes for it. Is there any reason that this application can be denied?
I'd have to see what comes in. That's a very hypothetical question. I'd have to see, you know, what they present, if they're asking for any variances, if there's no variances at all. There's always safety and safety concerns, but it has to be on the site. You can't add things to, this board is not allowed to add requirements or add restrictions that the governing body hasn't put in their ordinance already. Your job is to look, what has the governing body decided, what is appropriate? If an applicant proposes something that the governing body said is okay, you have limited ability to restrict or prohibit.
So basically, the difference would be in the variances they're asking for, is that the only changes that we can ask for?
Well, the variances are yes or no, would you grant them? The changes would be something if circulation is more appropriate or something's more appropriate, but that's kind of on a case by case in how they present it. But there's, if it's a permitted use and they are not seeking variances or very minimal, there's, in a general hypothetical, I'm not talking about this case at all, limited ability for this board to change the rules. Those rules are set by the governing body.
Well, I wanted to do it for the benefit of our homeowners, that you do have some understanding of what's involved here. So,
Yeah.
I hope that helps.
Sorry. Now you sparked more questions. Carl Ring, 22 Dayton Road. So, going back to, like, you said the decision would be happening here, but like, if I'm not mistaken, Speedwell is technically a state route, correct?
Yes.
And so if there is potential like traffic impact or something, does the state have to weigh in at some point because of the fact that Speedwell is a state route, or like, is that a possibility of further complications of like the decisioning process or anything like that?
Well,
or?
the applicant has provided a traffic report, okay? It's very extensive, you can read any of these documents over at the annex. And we have our own traffic expert, and he will testify as well.
Okay.
Yeah, one thing?
Yeah, sure, well,
Oftentimes, applications require approvals from other outside agencies, and every resolution, every time this board decides on something, there's always conditions. And before you can build or do anything, you have to have all your other state, local, and whatever approvals you need. So sometimes it's DEP, sometimes it's the county road, you have the planning board. This board doesn't do that. They say, we can look at, this board can look at what Morris Plains has, the rules they put in effect. But they also reference, before you go for a building permit, you have to have all your other permits in line too. We don't decide that, but that is a condition of any approval.
Right, so just level setting on sort of like the timeline and the process, like, there's potential that like, you guys may have to hold up your decision
No.
because you're waiting for the state to give.
No, oftentimes those are done on a parallel track,
Okay.
and it is simply conditioned upon it. The only thing that would change, and this happens very rarely, and this is a hypothetical, this has nothing to do with this application, is that sometimes there is an application where it's on a county road or something like that, where they are running a parallel track, but a decision gets made in one place, and the other entity deems that a change should be made. Then it would have to go back to the other one, a significant change. But that's really the only time that there's a problem. So
Yeah.
often they're separate decisions.
Okay, alright, thanks.
Any other questions? Yes, come on up.
Hi, good evening. Jessica Williams, 22 Stony Brook Road. So you mentioned that McDonald's will be bringing in experts. My question is, what type of information is the public given? Is there any discovery process where we're allowed to do some research on who these experts are, or?
Absolutely, absolutely. They have to provide all of their qualifications,
Okay.
and the board has to accept them as experts, okay?
And that's done, that'll be done?
That'll be done in public, that'll be done at the meeting as they each get up to testify.
Okay.
And they will be sworn in so that their testimony, they are under oath.
Okay, so, but we won't get, I mean, is there any information that we're gonna get on these people prior to September 16th?
No. Come on up.
Jill Cecere, 11 Dayton Road. I have two questions. Piggybacking on hers, will we know which experts will be at which meetings? Because I believe this is not going to be done in one meeting.
Probably, you want?
You may, but the way an application are governed by the municipal land use law, that's a state law that regulates how applications go forward. They are aimed at the applicant having to do certain things and then having the right to go forward. They do not, we have to follow both the ordinance and state law. We can't require more than the state says we can require. And I should say, all that is, what it is a checklist. They have to provide all the information, and then it's the applicant's show. They can determine who goes and when they go first. State law does not say that they must say in advance who it's going to be. The questioning has to be reasonable, so if they put on the first person and there are a lot of questions, then they're not gonna get past that person the first time. If they're, but no, by state law, municipal land use law does not require them
So
to
if you
say
miss
who is gonna be.
a meeting and you had a particular question for an expert, then the next meeting you can't ask it because that expert's not there to
Oh, no,
answer it?
the board can require that experts be fully questioned by the board, by our professionals and experts, and the public.
No, I understand, but if I didn't come to the next meeting for some reason, and it happened to be an expert that I wanted to speak to, I can't ask questions at the following meeting because that expert's not there anymore.
But at the end you can, okay?
They'll have all the experts here at the end?
Probably.
Okay.
I would, maybe.
And then another question just on the process. Is it common to change the permitted uses of land with the anticipation of an application coming in?
Now, I'll address that real quick.
Yeah.
Years ago, they used to be, and there was something that was called the time of decision rule. So, it used to be the rule that an application came in, the board started hearing it, the governing body, before the 2 days before the board made a decision, could change the use, and then they were out of luck, and then it had to be denied. The state said, this isn't fair, this is crazy, an applicant shouldn't have to go through that whole process and change the use. Now it's called the time of application rule. So once an application gets submitted, rules can't change. No use can be done. So once the application is in, nothing can change. The
No,
rules.
but prior to an application coming in, like a whole bunch of different areas had different permitted uses changed in October. But were things added or deleted to any of them? I'm not talking just particularly this one. Because of the anticipation of an application coming in for that use?
No, absolutely not. I
Because-
mean, this, as, you know, Mr. Kelly spoke, this process where, we reviewed and then the governing body adopted an ordinance for the permitted uses in non-residential zones.
Right.
And, members of the governing body had requested that the planning board do that, make the recommendations, because they wanted to, provide more, let's say, contemporary uses. Things like, for instance, in some areas you could have a brewery that we never had before, but that wasn't a thing before.
I understand
Okay.
those changes.
So that process took 2 years, a lot of back and forth, a lot of with our planners, with our engineers, I mean, long time. This, Friendly's was there for this particular one, so that was already a permitted use.
Well, a restaurant was.
Right, and,
But then it was changed to a drive-through.
correct.
And I just wanna make note that the realtor for that property was advertising for a drive-through, a year prior to it being approved by the town. That's all I'm gonna say.
I think it's
I have-
best,
I have
think it's best not
screenshots.
to talk about this specific property, number one, because board can't consider it. So I think
Okay,
if
I'm
you think
just-
things relevant, they simply can't,
Probably
it
can.
cannot be part of the application.
I was curious if it was the permitted uses
Let's not
were
talk about it.
changed
Okay.
because of that.
Are there any other questions? No? Okay,
Madam Chair?
yes.
I would just like to, tell members of the public, my phone number and my name will be on the notices that go out to everyone within 200 feet. But if you're not within 200 feet, my name is Frank Vitolo, and my cell phone, I don't see anyone writing, so I'm not gonna give it to you. It's I lived in Morris, listen, I lived in Morris County my whole life, I have kids, I own a house here, etc. So I'm a human being too. You could call me if you have questions about the application as well. You could look at the materials, but I also, like I said, offer my cell phone, which is 201, and that's from my old days in Hoboken. I don't want anyone saying, oh, that's a Hudson County number. 201-424-0492. And call me anytime if you have questions.
Frank, can you repeat your number, please?
Yeah, 201-424-0492. You can call the attorney for these projects. It's not, when I did Restoration Hardware in Morris Township, I met with the neighbors all the time. So if you guys have questions, give me a call.
Thank you very much.
Yep.
Okay, if there are no other questions, we will move on to the committee reports. The minor site plan committee. I don't think that Mr. Bezel is here. Master plan review committee. Do we have any new business? Do we have any old business? Okay, then will someone make a motion to adjourn?
So moved.
Second?
Second.
All in favor? Our next board meeting is September 16th.